This program is brought to you by Emory University.
Very happy to be here and be able to participate in this event. And I just want to congratulate all the students at the International Law Review for a really terrific job in putting together this event. I'm going to be very quick in introducing this panel because I know we have a lot to talk about, and I want to give all the time possible to our two distinguished panelists. This panel is looking at retributive justice and restorative justice. And in this respect, I think what we're going to hear a lot about is what are the issues and consequences of the various roles that an international tribunal plays beyond the role of determining accountability in a specific case. There are so many more aspects to what an international tribunal does, what it can do, what it might do in the future. So I think it will be really interesting to hear about that, because that's a very different aspect of a justice system than what we think about when we think about domestic justice. So I'm very happy to introduce our two panelists. Immediately to my right is Dr. Zachary Kaufman, who's currently a fellow at Yale Law School, the School of Management's Program on Social Enterprise, and the Genocide Studies program, all at Yale University. His research focuses primarily on international law, transitional justice, with a specific focus on Rwanda in many cases. And he is the co-editor and co-author of After Genocide, Transitional Justice, Post-Conflict Reconstruction, and Reconciliation in Rwanda and Beyond. Our second panelist, farther down to my right, is Kevin Cieply, professor at John Marshall School of Law, right here in Atlanta. He teaches international criminal law, and trial advocacy, among other topics. Professor Cieply spent 22 years in the U.S. Army and the Wyoming Army National Guard before transitioning to academia here in Atlanta. He served as a helicopter pilot and a judge advocate, so I know he's very good at navigating as well, so if any of you have any trouble getting home afterwards. But his last posting before leaving the military was Chief Land Operations Law at NORAD and NORTHCOM. And I'm very delighted to have both of them here, and Dr. Kaufman is going to get us started. Thank you.
Thank you very much. It's my first time to Georgia, and I can't understand this. What happened to Hotlanta? That's all everybody says about it, and it's very different. So thanks a lot to the Emory International Law Review and to Emory Law School for having me here today to discuss retributive justice versus restorative justice. And thank you to Professor Blank for moderating this discussion. And it's an honor to be on the panel with Professor Cieply. I've been asked to focus my comments on the restorative justice aspect of this equation and how it features particularly in post-genocide Rwanda. And I'll start by briefly outlining the concept of restorative justice, especially as compared to other forms of justice, and then I'll discuss the Rwanda case in particular. So in my last book, which Professor Blank mentioned, After Genocide, my colleague Phil Clark and I discussed three broad categories of justice: retributive, deterrent, and restorative. Retributive justice holds that perpetrators must be punished to bring them to account and to impose sanctions that they supposedly deserve. Some argue that retributive justice is also necessary for states to fulfill their obligations under certain treaties. For example, Article 1 of the UN Genocide Convention requires contracting parties, of which there are currently 142, to prevent and to punish genocide. Even more relevant to the topic of today's conference, Article 17 of the ICC's Rome Statute, also known as the Complementarity Principle, holds that the ICC will take up a case only if a state which has jurisdiction over it is unwilling or unable genuinely to carry out the investigation or prosecution. So in other words, the ICC's default position is that states parties, of which there are currently 121, must prosecute atrocities under their jurisdiction. Deterrent justice also holds that punishment is necessary. However, in contrast to retributive justice, which looks back to crimes already committed, deterrent justice is more forward-looking. Deterrent justice may be divided into two categories, specific and general. The aim of specific deterrence is to discourage convicted criminals from committing future offenses. The aim of general deterrence is to discourage current or potential criminals at large from continuing or initiating offenses. Restorative justice holds, in contrast to retributive and deterrent justice, that punishment alone is insufficient to promoting justice. Punishment may be necessary, but it should be conducted in ways that enable victims and perpetrators to rebuild relationships both among individuals and throughout the entire community. Restorative justice's main principles are the victim's right to have crimes acknowledged and addressed, and the perpetrator's right to be reintegrated into the community. In order to help rebuild fractured relationships, restorative justice employs various strategies, including hearings that are designed to be participatory, including of both victims and perpetrators, and that perpetrators acknowledge wrongdoing and provide compensation or other reparations to victims, often directly so. Restorative justice's overall aims are to help victims heal, to make perpetrators aware of the harm they have caused and to understand their duty to repair such harm, to prevent future harm, and to build or rebuild the self-worth or the self-confidence of both victims and perpetrators. It's important to emphasize that justice mechanisms may include a combination of retributive, deterrent, and restorative justice principles and outcomes. For example, traditional criminal trials, like we're used to in the United States, may punish perpetrators consistent with retributive and deterrent ideals. Several aspects of the Rwanda case make it special and an especially challenging case for transitional justice. A huge portion and proportion of the country both killed and were killed during the genocide. And combined with the fact that the international community invested a significant amount of money into the accompanying war crimes tribunal, but comparatively little into other transitional justice mechanisms, several consequences followed. There was widespread demand, both within and outside Rwanda, for some sort of meaningful transitional justice system. Those demands ran the spectrum of justice types. Some championed restorative justice, while others championed retributive justice. Given the sheer number of génocidaires, retributive justice alone was not feasible. Some had, by the way, calculated that somewhere between 500,000 and 1.2 million people committed genocide or otherwise participated in the crime. And so for this reason, even for many of those for whom restorative justice was not desirable, it was viewed as necessary. And relatedly, both because the optics of mass executions were unsettling, at one point the Rwandan president, Paul Kagame, said that more than 1 million people might have to be executed. And in order to encourage the transfer of cases from the ICTR to Rwanda, Rwanda abolished capital punishment in 2007. After the genocide, Rwandan prisons were terribly overcrowded. That situation was unsustainable and led in part to the Rwandan government releasing tens of thousands of inmates. Many able-bodied Rwandans who remained behind bars were not contributing economically to their families and communities. Worse, because their family members often brought them food to supplement their rations from the prisons, they were a financial drain on their loved ones. Génocidaires often killed their neighbors during the genocide. After being released or serving their sentences, many suspected or convicted génocidaires returned to their homes, meaning that they would continue to have frequent, even daily contact with genocide victims and survivors. There have been 4 main transitional justice mechanisms for Rwanda. 2 mechanisms outside Rwanda, the ICTR, the International Criminal Tribunal for Rwanda, and also foreign prosecutions in individual states. And then 2 mechanisms within Rwanda, Gacaca, which I'll talk more about in a second, and domestic prosecutions. Because they relate most to the debate over justice types, I'll focus on the ICTR and Gacaca. On November 8, 1994, just a few months after the genocide ended in mid-July, the Security Council established the ICTR to address génocidaires, the perpetrators of the genocide. The subject matter jurisdiction of the ICTR was limited to genocide, crimes against humanity, and other certain select atrocities. The temporal jurisdiction of the ICTR was limited to crimes committed just during the calendar year of 1994, so nothing before and nothing after. The personal and the territorial jurisdictions were limited to crimes committed by Rwandans in the territory of Rwanda or of neighboring states, as well as by non-Rwandan citizens for crimes committed in Rwanda. The Security Council located the seat of the tribunal in Arusha, Tanzania, so outside the country, outside of Rwanda. According to the latest annual report by the ICTR's president, the ICTR has completed judgments at the first instance, at the trial level, of 68 people, and judgments at the appellate level of 43 people. Since its inception, the ICTR has spent over $1 billion. The Security Council resolution establishing the ICTR included introductory clauses that articulated the Security Council's mission concerning the tribunal. The resolution stated that the Security Council sought through the ICTR to halt atrocities in Rwanda, to pursue accountability for their perpetrators, and to provide effective redress for their victims, to promote reconciliation and peace within Rwanda, to strengthen Rwanda's judicial capacity and system, and to deter atrocities elsewhere in the world by making it an example of the Rwandan genocide. This resolution would suggest that the ICTR's mission included a combination of retributive, deterrent, and restorative justice objectives. Whether the ICTR is fulfilling its mission has been a source of controversy since its very formation. Critics charge that the tribunal has been consumed by nepotism, mismanagement, incompetence, inefficiency, waste, and insensitive treatment of witnesses. These individuals assert that in the 19 years since its creation, the ICTR has spent too much money, remember over $1 billion, expended too much time, and has occupied too many staff members on the completion of too few cases. Remember, at the appellate level, only about 43. These critics also state that because of a combination of the ICTR's location in Tanzania, which is adjacent to Rwanda, and what many have claimed is a really ineffective outreach program, many Rwandans are unaware of the tribunal's progress or even existence. Some also criticize the ICTR for bias against Hutu, claiming that Tutsi should also be tried for offenses they committed. And there were offenses committed after the genocide concluded. Others point out that the advent of the ICTR has not halted atrocities in the region, particularly in the DRC, or further away in, for example, Sudan. Overall, the critics charge the ICTR has not promoted reconciliation within Rwanda, has done little to help build Rwanda's justice system, has brought a meager number of genocidaires to justice, and has not sufficiently deterred the commission of atrocities elsewhere in the world. Proponents of the ICTR, some of whom concede errors, assert that the enormity and complexity of the task before the ICTR necessitates a significant budget, a large staff, a long timeline, and the selective investigation and prosecution of suspects. Even then, they claim the ICTR has helped establish a historical record of the genocide, incapacitated extremists, and officially acknowledged the suffering of victims. Defenders of the ICTR also note the significant precedents and other contributions to international law and justice that the tribunal has made. In contrast to the ICTY and the Nuremberg and Tokyo tribunals, which addressed international conflicts, the ICTR was the first international court to have jurisdiction over atrocities committed during a purely internal conflict. In addition, the ICTR was the first such tribunal to receive a guilty plea for genocide, to impose the first genocide conviction, to indict and subsequently convict the first head of government for genocide, to clarify the definition of rape in international law and to hold that it could constitute genocide, and to pass the first genocide conviction of journalists. And on that note, we're very honored today to have Ambassador Rapp with us here. When he worked at the ICTR, he was a senior trial attorney that oversaw that media case. Its proponents thus claim that the ICTR, despite having what they asserted as a limited mandate and resources, has indeed contributed to accountability, reconciliation, and peace in Rwanda, and atrocity deterrence more widely, even if those achievements are not yet apparent and will be realized only in conjunction with other efforts such as Rwanda's national and local justice systems, including Gacaca. Gacaca stems from a traditional conflict resolution system that the Rwandan government revived and revised to address the overwhelming majority of genocide cases, those not dealt with through the ICTR, Rwanda's federal courts, or foreign courts. In 2001, Rwanda instituted the Gacaca jurisdictions, ultimately convening approximately 9,000 courts. Like the ICTR, Gacaca arguably incorporated elements of retributive, deterrent, and restorative justice. The law constituting Gacaca declares that it is designed not only with the aim of providing punishment, but also reconstituting the Rwandan society that had been destroyed by bad leaders. Gacaca could impose punishments, including prison terms and community service. Many observers, though, note that Gacaca's primary objective was to promote reconciliation through restorative justice. By allowing victims to confront perpetrators publicly and directly before community members, including some elected to serve as judges. Actually, there were 250,000 people who were elected to serve as judges. Gacaca engaged the participation of previously antagonistic parties alongside the rest of the community. In order to prioritize the public in its proceedings, Gacaca excluded attorneys from participation, including as defense counsel. In addition to the fact that hearsay was an acceptable form of evidence and the possibility that the judges elected may have been biased, many critics argue that Gacaca violated basic standards of due process. The Rwandan government officially closed Gacaca on June 18, 2012, the 10th anniversary of the Gacaca proceedings. In its report at that ceremony, the Rwandan government, which stated that Gacaca had tried, these are amazing statistics, 1,958,634 suspects, convicting about 86% of them and acquitting another 14%. And the Gacaca courts reportedly heard appeals from 178,741 of those convictions, affirming 74% and reversing 26%. Because of its particular circumstances, Rwanda and the international community were compelled to consider innovative mechanisms to promote justice for the 1994 genocide. Through the ICTR and Gacaca, justice in Rwanda has been retributive, deterrent, and restorative. As Gacaca concluded just 8 months ago and the ICTR's work continues, it is still too early to evaluate how well that balance was struck. Thank you.
Good morning. Thank you also for inviting me. I'm Kevin Cieply from Atlanta's John Marshall Law School. Thank you, Professor Blank and Professor Kaufman and Emory Law School. I really appreciate the chance to address the audience here today and this important subject. First of all, retribution, let me start off by just saying that, at the basic level, retribution really is looking to proportionality in sentencing. And that is looking at the gravity of the crime, that is the harm that was caused, as well as the culpability of the offender. At the very basic level, if we go all the way back, we're talking about lex talionis, where an eye for an eye. The Hammurabi Code, said that if a man take the eye of a free man, then his eye will be taken. And if a man break the bones of a free man, his bones will be broken. We see this lex talionis also in the Bible, in the Old Testament, in Exodus and Leviticus and Deuteronomy. And so this is a very ancient concept that speaks to us at a very, very visceral level and has been really metastasized in our sense of justice throughout all of mankind. And so when we talk about retribution and international criminal justice, it is an extremely important element and piece of justice. In Nuremberg, when we brought together the Nazi defendants and the countries were trying to decide what to impose as a sentence, the death penalty, of course, was debated and was actually implemented as part of Nuremberg. 11 of those defendants were eventually sentenced and hung. And there was a sense at the time of a little bit of disappointment that kind of shows us exactly how important retribution really is in punishment, in that there was a sense of disappointment that the highest levels of the Nazi Party were not available to be tried and hung, and even a sense of disappointment when Göring took his own life after being sentenced to death, and so that the international community couldn't carry out that sentence of hanging General Göring. Of course, as the international community left or moved away from World War II and the human rights whole body of law started becoming developed, the international community more and more started moving away from the death penalty. And we see with the ICTR and the ICTY that death penalty was not part of the sentences that were allowed to be invoked. Some of the criticism, as Professor Kaufman talked about, particularly with the ICTR, is that the death penalty was not part of that equation, and Rwandans, the Tutsis, felt like the death penalty, by and large, should have been part of that, and so they did not want to push people over to Tanzania to have them tried under the ICTR. And we come to Lubanga, the first sentence by the ICC, and we've got an individual, and we're looking at retribution. First of all, if you look at the harm that is caused, taking children and enlisting them, using them, conscripting them into the army, and these are young children, a whole generation of children, and inculcating ethnic hatred, so that perhaps generations to come, we've got a cycle of violence. So it's a very serious crime, and this is done by a man, of course, when we look at his culpability and his mens rea. He's a middle-aged man, he's well-educated, he knew what was going on, he's a man that has power, positional power as well as influential personality, and so a person that everybody's looking up to in that particular community. And so when we look at the harm and we look at the culpability, this individual had a lot of harm and a lot of culpability. And what does the ICC hand out? 14 years, less than half of what it's allowed to hand out. And under the special court of Sierra Leone, similar crimes as this got up all the way to 50 years in imprisonment. So as a concept, I think, and I'm focusing on the ICC, as a concept of punishment, retribution, I do think is in peril. And when I say that it's in peril, I mean that it is degraded down to such a level that it's starting to lose legitimacy. And why do I say that? Well, first of all, just like the ICCTY and the ICTR didn't invoke the death penalty, so too the ICC does not invoke the death penalty. They cap the term in confinement to 30 years if it's a term, life, of course, in exceptional cases. But exceptional cases really should be the only kind of case, as Professor Kaufman talked about, Article 17, the complementary provision, in that if a national court can take this case, then a national court should take the case. And if the national court can't take the case because of some kind of disingenuous type of prosecution is likely to occur, then the court still has to analyze, is this a very grave crime? And so we're talking about a very selective crime, a very grave crimes, and what we've got here with Lubanga is we've got 14 years that's being handed out, and that's, of course, a communication that goes across the world. Now, some people may say that it's good that retribution is kind of losing its influence because philosophically, morally, and even socially, there's a lot of problems with retribution. It had developed basically with Immanuel Kant, a philosopher, talking about why we punish, and it's very much based into a religious concept of law being handed down by a deity in natural law, in that we can sense, everybody can agree on what justice is, and again, that basically if somebody does something, that they deserve it equally in kind. As the world has become more educated, that becomes a harder argument to make. Moreover, it's also criticized in that there's absolutely no way to achieve retribution, that is true proportionality on the international level, because as Dr. Kaufman pointed out, if you're dealing with, such as Rwanda, between 500 and over 1 million victims of genocide, how do you have proportionality? How do you bring in that many people and administer justice? It's almost impossible. Plus the crime is so grave in that trying to wipe out a whole community of people that there's just no way to bring any kind of restorative or retribution, to that type of situation. The other thing is that so that's the reason why some people aren't so sad with retribution being put out. But my position is that retribution is a necessary, although not sufficient, element of restorative justice. That is, in my opinion, you can't have restorative justice without first satisfying the element of retribution. When we look at the international criminal tribunals, basically we're looking at, I think, a communicative element to the proceeding. That is, what are we doing? We can only bring select people because of the costs. You heard over $1 billion ICTR, extremely expensive, extremely time-consuming, and so because of this, we can only bring the most serious offenders to the ICC. So what are we doing? We're sending out a message to the world. We're trying to bring a normative value to the world. And retribution is what the people that seek impunity, that's the type of language that they hear. I think that as academians, we somewhat, and as legal professionals, we somewhat have lost exactly what we're trying to do, because if we're trying to bring justice to these areas, there's going to have to be some kind of elemental sense of justice that's being brought. And retribution, that's what retribution is. Retribution is seeking justice, is seeking that can we make sure that what happened here is not an example, that we as an international community set a normative value, that this is wrong, and that you will pay a price. You can't hide, you will pay a price. And so you've got to do that in a symbolic fashion. You have to bring in the leaders, as we did in Nuremberg, and there has to be severe and quick justice. It can't linger for years and years and years, or it loses its validity. And as the ICC has established now with the first case, it falls short on all those different aspects. It falls short on seemingly taking into consideration the harm that was done, the culpability of the offender, the communicative value of the sentence. And that's where I feel like the ICC is now, if this is the route we're going, is really not going to do a whole lot.
Much. What I'd like to do is we have some time for questions. I'd like to start things off by tossing out a couple of questions for our panelists here and then open it up to the floor for questions from the audience. So what I'd like to do is put out two questions and invite both of you to share your thoughts on them. And the first one is a general question of where is the friction point between retributive justice and restorative justice? Kevin, you mentioned that they're inherently components in many ways. Obviously, in order to get restorative justice, you need a component of retribution. Where do they come up against each other? Where can the pursuit of one undermine the pursuit of the other? And related to that, the second question I'd put out to you both is how much should we be thinking about the role of other institutions that play a role in restorative justice as we think about this relationship between two kinds of justice within one tribunal's efforts? How much should we be thinking about other entities like truth commissions, whether it's domestic processes like gacaca or other alternative justice mechanisms, in order to fill that role of restorative justice?
I guess I'll start. So with the first question, where's the friction point of between restorative justice and retributive justice? You know, both of these terms, both of these concepts are pretty broad, and they're somewhat open to interpretation. So one interpretation would be that retributive justice very much focuses on the perpetrator, on punishment for the past, and in sort of just deserts. Restorative justice has more of a victim-oriented approach, and is more, sort of focused on the future in many ways, on repairing those relationships that have broken down between individuals and also within the broader community. And so the ways in which those then manifest can be quite contrary. So in some situations where you have, a trial, you might have very little victim participation. In fact, one of the sort of significant criticisms of the ad hoc tribunals has been that there's been virtually no significant victim participation beyond some key witnesses. The ICC learned from that lesson, and so has focused at least a little bit more on victims, but is still a sort of traditional trial-focused process. A restorative justice approach, like with Gacaca or with like truth commissions, in many ways focuses much more on engaging victims. It takes the view that these people had suffered, and as part of the process of rehabilitation, recovering, rebuilding, it's essential to include them in the process, and not just sort of, pull from among them a few examples for the very limited purpose of eyewitness evidence or other sorts of testimony, but as an actual stakeholder and partner in the process. So because of the ways that those manifest, there really can be significant tension between the two. As for other institutions in restorative justice, beyond war crimes tribunals, there of course are lots of transitional justice options. There are, Gacaca is sort of a new type, although it was resurrected from and modified based on an old system in Rwanda. But before that, as Professor Blank said, there are truth commissions. There are also, I should mention, different types of truth commissions. Some sort of operate in the shadow of prosecution if you're not fully cooperative. That's the example that was used in South Africa, and then others are purely focused on just providing sort of more of a blanket amnesty in exchange for truth. There are also then blanket amnesties, exile, lustration, which is purging people from government, and also inaction, sometimes as a strategy, as a deliberate strategy of dealing with a situation. And so what's the place? Well, in the world that we live in today with the ICC, given the ICC's focus on prosecutions, it would seem to deprioritize the role of alternative transitional justice mechanisms. And indeed, this has been a significant controversy both in the field and in the literature about what should be the interplay between these different transitional justice options, some of which historically have operated sequentially or simultaneously. But it seems now that we're developing much more of a norm towards prosecution, for better or worse. And so, I think that Rwanda is sort of a very interesting case where we've seen multiple transitional justice options operate at the same time and to varying degrees of success.
So on the first question, what I think of and what I try to remind myself of every time when I'm going through this subject is a case that I had at Fort Carson as a young JAG officer. It was a child molestation case, and I was prosecuting a captain. He had molested his stepchildren. When they first came in through the victim advocate, the children were fairly cooperative. After I explained through the victim advocate to the children as well as the mother who was being abused, basically what was going to happen, then suddenly the victims recanted. And that is because I was going to send their father to jail. He was going to be kicked out of the military, and he was going to lose all pension as well as medical benefits. And so at that point, it really hit me of where this intersects. That is, you can have retribution as far as part of your justice equation, but if that's going to hit the people in the way that it was hitting here, the people that you're actually trying to protect, then there are limits to retribution, and you have to look beyond that. On the other hand, whenever you're arguing for a sentence in court, a lot of academians will say that these philosophies or these theories of punishment are diametrically opposite each other. They can't. You can't be one way. You've got to choose one or the other. But every time you argue for a sentence in a criminal trial, you are hitting on each one of these elements. And if you're not, then you're actually not making a sound or good argument for your client, whether it be the government or be a defendant. And so the problem, I think, on the international level is that you can't, like I said, just with the number of people that are typically involved, there's no way to achieve true retribution. And that's why I think the value of retribution on the international scale is the symbolic message, is the communicative element of punishment that Professor Feinberg talks about, and that is that, we're trying to set a normative standard for the world, we're trying to bring the world up, we're trying to grow, and part of that equation is the sense of justice. When people don't have a sense of justice being done, it is very hard for them to move forward and feel restored. If you look at even in America, when you're talking about Oklahoma City bombing with Timothy McVeigh, I just came from Guantanamo 2 weeks ago, and for the El Nashiri hearings, and after the hearings were done, then the families came up. There was a press conference, so prosecutor came up, then defense came up, and then the family came up, and I would say there was probably about 10 family members of victims there, and every single one of them wanted the death penalty. Every single one of them, and one person stood out and said, "If you don't have the executioners, then just ask us." So retribution is definitely at the victim level a very visceral thing, and I think we've got some challenges on the international level if we're going to start trying to not do anything more than symbolic type of prosecution. As far as the second question, Dr. Kaufman knows infinitely more than I do in that area, and so I pretty much don't have a whole lot to answer on that, other than I think that when you're looking at different venues, that reverting back to the national courts has got to be a little bit, there should be really good reasons not to have national courts, because the international courts don't really resolve anything. I mean, they say, well, the national courts are going to have, that people are going to be bribed and you're going to have corruption. Well, the international courts, you have the same critique of those. And then they'll say, well, they're just, if people can't be protected, well, you can take measures to protect people. But the moment you move it outside of the borders of a country and you put it off in a faraway land, the victims can't see what's going on. The news isn't there. There's not a sense of context of what happened in the event. It's seen as outsiders doing things. And so there really, really should be some very good reasons to take it out of the national courts.
I think we have time for one quick question and very quick answers. If anybody has a question, and I'll just ask you to make it very brief, please, in the interest of time.
I'm John Washburn, convener of the American NGO Coalition for the International Criminal Court. My question has to do with a relationship between these two concepts, which Professor Cieply has already started to touch on. I want to ask, though, whether that relationship has been somewhat obscured by misnomers that the two of you are using. It seems to me that Dr. Kaufman is, in the substance of what he has said, is not talking about restorative justice in the sense that a woman who has been gang raped can somehow be restored to what she was before that happened to her. And it seems to me that Dr. Cieply is talking not about retribution in the sense of revenge, but that what he's really talking about is punitive justice. If I'm correct about that, gentlemen, don't we have a relationship in which punitive justice, which does for victims what Dr. Cieply has already started to talk about, serves the cause of the redressive justice that Dr. Kaufman is speaking of?
I wouldn't disagree with anything you had to say.
And as I mentioned too, I mean, these are broad concepts that, have lots of different definitions. Of course, there would be no way at all to restore a rape victim to their former self or situation. And indeed, gacaca does have elements, as I tried to draw out with, of both restorative and retributive justice. It is certainly part, as you're indicating, of the restorative process of the rebuilding within the community, that at least some of the genocide perpetrators be punished. And so I think you're absolutely right that, there can be a very significant interplay between the two concepts. And in gacaca, I think we see that played out very significantly.
Join me in thanking our panelists for a very interesting conversation.